Barry, we're here talking about whether and under what circumstances an attorney can receive compensation from a third-party consultant for referring work to that consultant. My first question is a basic one. Can an attorney receive compensation under such circumstances?
The answer to that is yes, and I'll explain. But Emily, first I'll do what most lawyers do, and that's provide a little disclaimer on this video. I am a lawyer, and I've looked carefully at the questions that we'll be talking about today. But I'm not providing legal advice to anyone that's watching or listening to this. So, to answer your question, the short answer is yes, a lawyer can receive compensation for referring a client to a third-party Medicare consultant. The longer answer is that it is a conflict of interest for a lawyer to receive compensation for that kind of a referral, but that conflict can likely be waived with the client's informed consent confirmed in writing. Does that make sense?
Yeah, so tell us what that conflict of interest is.
For attorneys, a conflict of interest occurs whenever a lawyer's duty to zealously represent and advise his or her client comes into conflict with any other motivation or duty. Commonly, a conflict of interest arises when an attorney has duties to a current client that conflicts with duties owed to another client or to a former client. But a conflict of interest also arises when a lawyer has a personal interest, like a financial interest, that's at stake.
What do you mean by financial interest? Does a referral fee constitute as a financial interest?
I think it does. A referral fee most certainly is a financial interest for the lawyer. And that's what we're talking about today, right? A lawyer receiving a referral fee for providing client information to a third-party Medicare consultant. I think we can all agree that the lawyer has an obligation to refer that client to the best Medicare consultant there might be, regardless of the consequences, positive or negative, to the lawyer. But as soon as the lawyer reaps a personal benefit for the referral, a referral fee, for example, all of a sudden the lawyer isn't necessarily acting solely in the client's interest. Rather, the lawyer could be acting for his or her own interest over the client's interest, referring the client to someone not because that person is the best at what he or she does, but because that person is paying the lawyer a referral fee. Mm-hmm. That is inherently a conflict of interest.
Now, is there a specific rule that addresses lawyers obtaining referral fees from non-lawyer consultants, or is it just the general conflict of interest?
It's just the general conflict of interest rule. But there are some specific rules dealing with other instances involving fee sharing. Specifically, Rule 5.4a of the Model Rules of Professional Conduct prohibit, with some exceptions, a lawyer or law firm sharing a fee with non-lawyers. But a referral fee from a third-party consultant is not the same thing as a lawyer sharing a fee that the lawyer earns for performing services. Rule 1.8 also generally prohibits lawyers entering into business transactions with clients or knowingly acquiring an ownership, possessory, security, or other pecuniary interest adverse to a client. But a referral fee arising from a third-party consultant is not necessarily adverse to a client's situation. Like, say, for example, being on the opposite side of a real estate transaction with a client. That's an adverse circumstance that we're talking about.
The existence of conflict of interest sounds pretty definitive and kind of like the end of the question. So how can a lawyer obtain a referral fee from a third-party consultant even though there's a conflict of interest?
Good question. The existence of a conflict of interest answers only one of two threshold questions. The first is what we've been talking about, whether the referral fee creates a conflict. It likely does. But the second is whether that conflict of interest is waivable by the client. In other words, can a client say, okay, I'm fine with this situation. I understand there is a technical conflict of interest here, but I don't think it really keeps you, meaning the lawyer, from doing your best for me. So I'm okay with you proceeding in this way and receiving a referral fee. Some conflicts of interest are not waivable, no matter how the affected client or clients might feel about them. But other, and indeed many, conflicts of interest are waivable. The notion of an attorney receiving a referral fee from a third-party consultant is one of those kinds of conflicts, one that is rather easily waived by the client, assuming the waiver is properly undertaken and obtained.
So how would a client properly waive a conflict of interest?
Much of that waiver boils down to the concept of informed consent confirmed in writing. Two requirements: informed consent confirmed in writing. Informed consent is defined. It means, quote, an agreement by a person to a proposed course of conduct after the lawyer has communicated adequate information and explanation about the material risks of and reasonably available alternatives to the proposed course of action, end quote. A writing is broader than you might think. It is a tangible or electronic record of a communication or representation, including handwritten, typewriting, printing, photostatting, photography, audio or video recording, and electronic communications.
That's a lot of terminology. What's the takeaway?
It is a lot of terminology. But long story short, a client may waive a conflict if the lawyer gives the client enough information to allow the client to make an informed, educated decision about what to do. This level of information should identify the specific conflict in as much detail as reasonably practicable to give. This is a simpler type of conflict to disclose than other conflicts because it's really pretty cut and dried. I get X amount of dollars for referring you to ABC Consulting. Are you okay with that? May I give ABC Consulting your information? So you're disclosing the payor, the amount of the fee, and the reason for it, and giving the client an opportunity to make an informed decision about it.
How much information does the lawyer have to provide?
The short answer is enough information so that the client knows at a minimum the lawyer is receiving a referral fee, that the lawyer is receiving that referral fee from a consultant, that it isn't a one-off thing, that the lawyer has referred other clients to that consultant. The lawyer should disclose that he or she gets the referral fee. The lawyer should disclose the amount of the fee, and generally, the more information you disclose, the better. It's also an opportunity for the lawyer to explain that despite the fee, the lawyer would still refer the client to the third-party consultant because that third-party consultant is the best at what it does.
How does this waiver get memorialized?
It has to be in writing. This is one thing that must be in writing. Often conflict waivers are memorialized in written conflict letters. The letter spells out what the conflict is. It refers to applicable rules of professional conduct, and it memorializes the waiver. The client signs the waiver. This is usually done and should be done at the outset of the representation. At the same time, the lawyer discloses that he or she may be consulting with a third-party Medicare consultant. But the definition of a writing, we need to remember, is rather broad. An audio recording of, say, a telephone conversation suffices, because the audio recording is a written, documented transcript of the telephone conversation. The conversation should include a complete dialogue containing the information that we've talked about in the waiver.
Well, thank you, Barry.
Absolutely. You're welcome, Emily.